I got 4 of you in currently, and I have a surprise guest today. And I'm going to keep letting people in as we're here. I have Joel here, which is a senior paralegal at Fast Eviction Service. And I'm going to keep letting you in, but if you guys got questions, feel free to pick our brains while you got us, because I don't have Joel for very long, but he's going to talk about the new extension in LA County, the new tenant protections that go to the end of the year, right?
Right.
Wow. I'm going to move us back just a little bit so you guys can see Joel, and we'll hear what Joel has to say. Can everybody hear us okay? Can somebody just let me know with a little message or something with a thumbs up that you guys can hear us good? Please.
Hello.
Yep. Okay. So we got participants in here and you guys can hear us, correct? Everybody's good? We have good sound? Somebody type something. Hello. Stacy, can you unmute you and tell me that you're here? I just want to make sure you guys can all hear.
We're here.
Hello. All right, so you can hear us good?
Hear you great.
Okay, and I'm going to keep letting people in. Joel's going to talk about the new extension of the moratorium in LA County and what that means for us.
Okay. Good morning or good afternoon. First of all, I'm not an attorney. I am, as Widget has explained, the senior paralegal for Fast Eviction Service, Law Offices of Michael Earl. My job is to keep abreast of changes that have been made, both to state law and local law, County of Los Angeles, City of Los Angeles. The County of Los Angeles decided last month to extend the county's moratorium to evict a tenant in certain circumstances. However, the county's extension of their moratorium cannot preempt state law. So there's 2 concerns that we have regarding the county's extension. First of all, the county has extended in 2 phases. Phase number 1 starts February 1st, yesterday, and it goes through May 31st. And then phase 2 starts June 1st and goes to the end of the year. The limitations on tenant residential evictions include no fault evictions, except for qualified owner move-in evictions, and they've changed that as well. A nuisance eviction in LA County cannot go forward. However, I believe in reading state law, Civil Code Section 1946.1 and .2 allow for nuisance evictions. I don't know how the court will reconcile those 2 issues. Unauthorized occupants or pets is excluded in both phase 1 and phase 2, and denying access to the landlord to make necessary repairs, inspection, and the like is also excluded under the LA County extended ordinance, but not under state law. And we don't know how that's going to play out. Move-in restrictions have changed a little bit to the date of purchase by the new owner or by the owner who wants to move in a family member, spouse, grandparent, child. They have to have purchased the property on or before June 2021 and have to move in for at least 3 years and show they're going to move in for 3 years and show that they are significantly similar to the tenants who are currently living there as to age, income, disability, and the like. So that's a significant difference between state law and county law. As far as evicting a tenant for non-payment of rent, residential tenant for non-payment of rent, that's changed as well. First of all, the county has what is called a self-certification form, which is similar to the declaration form of financial distress, but is different in that the tenant need not show any income qualification at all until June of 2021, where they will have to show that they make less than 80% of the average income within the county.
The median income.
Yeah, the median income. So those are significant changes in the county. Commercial evictions have also been changed. We now can evict a commercial tenant for non-payment of rent if the commercial tenant does not fill out one of the self-certification forms and provide income information to the landlord for non-payment of rent January 2022 onward. Back rent is still considered a moratorium against eviction. Again, if there are 9 or less employees, then they qualify for that eviction protection. LA County is really trying to supersede the state law right now. State law allows for evictions for nuisance, allows for evictions for non-payment of rent, requires the tenant to provide not only a financial distress declaration, but if it's a failure of forfeiture, the tenant must provide additional information within a certain timeline. The county doesn't change that timeline, but changes the requirements to where the tenant does not have to provide specific financial information until June of 2022, when they'll have to show that they make less than 80% of the median income in the county of Los Angeles.
I have a question.
Sure.
I know that we're seeing heavy restrictions in heavily populated areas. I learned that from the COVID pandemic, that where we have heavily populated areas, we have heavy restrictions for landlords. Can we most likely expect to see this also pop up in San Diego, because that's our other heavily populated county within the southern counties of California?
Yes, and we're also seeing that it's popped up in Orange County, the city of Santa Ana. They have a new extension which kind of coincides with the LA County new eviction moratorium law.
So is it relatively safe to say, and I'm reaching for straws here, folks, that in counties like San Bernardino, Kern County, that Riverside County, we may not see additional protections for tenants because they're less populated than our metropolises like San Diego and LA?
I think that's a good analysis, yes. Riverside and San Bernardino, other counties have not adopted or extended their prior eviction moratorium, so they're all governed by the state.
So from what we see in surrounding counties, we're most likely going to be back to business as normal on April Fool's Day.
Yes, with the exception of no jury trials. If a tenant, and they all do, and they're all getting representation through every legal aid organization in the state,
They know.
demand jury trials.
They know.
And no jury trials are going out at this time. San Bernardino County has put a moratorium on jury trials in every civil case, but that doesn't mean your case is going to get to trial if it's a bench trial, because the courts cannot deny the tenant the right to a jury trial unless the Constitution of California is amended.
Wow. How about you guys? If you guys have questions, please make sure you ask them while I have Joel, because I'm not gonna have him forever. And I'm still admitting people in, just so everybody knows. But LA County has basically thumbed their nose at us landlords and said, buckle up, I'm taking you to task for till the end of the year, right?
Pretty much. Pretty
Okay,
much the social activists in LA County through firms like Eviction Defense Network, BOSTA, the County Board of Supervisors, which are very liberal, believe that their job is to protect the tenant and ultimately, and this is my opinion, ultimately would like to see free rent for everybody. And no evictions, the landlord eats the rents. That hasn't happened yet, but with the way the legislature is changing in the Board of Supervisors, the city council for some of the other jurisdictions, it's only time until they try to pull that. And I think landlords, property managers and the like have to be very diligent and be willing to challenge some of these ordinances in court with declaratory relief lawsuits.
yes, I'm sure we'll see part of the apartment association step up for us and go to bat with us in filing lawsuits as they have done throughout the pandemic period with various organizations like AGLA. I know they have several lawsuits pending,
Right.
trying to get justice for us as landlords. If you guys have questions, please type them in there or unmute yourself and ask the question why we have Joel. He's one of my experts. He's one of the people I go to when you guys ask a question I can't answer. Okay, here we go. Is the state going to pick up the tab? You're funny, Val. I like you.
No, and what's happening now is most of the rental assistance funds are
They're diminishing.
drowning in requests. And so where the idea is for the state to pick up the funds through the grants and money they get from the federal government, that's not going to last much longer. So unless we see some push in the state legislature to get more rental assistance funds for the landlords, that's not going to happen.
Ouch. Okay, hold on. We got another question. Who will pay?
For the rent, you're going to have to file a lawsuit ultimately against the tenant for all the back rent that's owed. If there's no rental assistance money available, then there's no funds to obtain for rental assistance.
So you would most likely prevail in the eviction, most likely.
Yes.
Pay
Us.
attention.
And one of the things that is concerning to us is the fact that the landlord's access to the court system is going to be severely limited by the lack of courtroom staff, the lack of clerks, the inability to get documents filed through the system, and the length of time.
We're already seeing a delay, just so you guys know, with the sheriff and the court systems with the Omicron variant. It's wiping out whole offices. And they'll come back in 10 days, but we're gonna see another bit of a delay because of the Omicron variant, just so everybody understands that. I'm witnessing it firsthand. The sheriff's department, one of them gets sick, both of them get sick. Now they're both out for 10 days and everything just got backlogged by 2 weeks. That's how easy that is to come about. I know your legal counsel is fighting for you with everything they got, but you guys, we can't be frustrated with the lack of competence at this point with the illness that's going on. It's hitting people hard. So keep that in mind. We also have another question. What about rent increases in LA County? Is LA County considered LA City? When can rents be increased in LA County and LA City?
According to the new ordinance, no rental increases will be allowed after February 1, 2022 in the unincorporated area of LA County and in LA County. LA City has not spoken about that, but the moratorium in LA City has not expired because the mayor has not said the pandemic has expired, has not declared that the pandemic has expired. So the city of LA ordinance remains the same as it has been until the mayor declares the end of the pandemic.
And can I raise my rent in incorporated city of Huntington Park still? Based on what you just said?
That incorporated city of Huntington Park, they don't have their own eviction ordinance and it's not an unincorporated area. So I do not think the limitations in Huntington Park properties would apply. You'd be able to increase your rent by no more than 10%, no more than 10% or 5% plus CPI. Consumer price index for the area.
They're aware of that. I try to educate my team as much as I can.
Okay, good.
And we talk openly. We all say, let's go. I won't say it.
Right. One other thing you must also be aware of is that the exemption notice that was in AB 1482 is now included in Civil Code Section 1946. So any new lease that you have must have that exemption notice. If that lease has not expired and did not have the exemption notice, immediately send out a notice to all the tenants that you're exempt.
It would be a better business practice to serve a 30-day notice of change of terms, letting them know that you're exempt. Correct?
That is correct.
I can't tell them what to do, but I can tell them what a better business practice is.
That is correct.
Wink, wink, wink. So if you guys didn't disclose that you're exempt from 1482, what we're suggesting is that you do that now with a 30-day notice of change of terms of tenancy, because it will help you in the long run. Trust us. Any more questions from you guys? We got to ask him why we got Joel, because he's a very busy man. I'll still do all your other questions, but don't ask me anything about that yet. He's got a book in his hand, no joke. Just in case you ask him something, he has to look up. You mentioned on one of your Zoom meetings that if the property in the city of LA under a living trust, we can increase rent on April 1st. Well, not necessarily. April 1st would have been the date that expired, but now it's most likely going to be extended also if you're governed by RSO. That has some controls in there.
It does, and if you're going to increase the rent, you have to make sure you have that notice of exemption. A living trust is considered an individual because there's an individual trustee. And therefore, they're exempt from the requirements of what used to be AB 1482, and now is this part of the Civil Code. So you will be able to raise your rent, but keep checking with the registration with the LARSO as to the amount they're allowed. Right now, they have very specific requirements for raising rent, and you can find that on their website.
And again, this is me talking to you guys, and we'll get to your question, G. Jones. Just give me a second. Just so you guys completely and totally understand, none of this is considered legal advice. It's all operational process and procedure for full disclosure, okay? But please pay attention. Okay, let's get into your question. Going back to LLCs from the other week, we are member-run LLCs except from just cause eviction restrictions versus corporate-run LLCs. I think what you're asking is if your LLC has a member in the LLC that is a corporation, then you would have the statewide rent control. If they're just LLCs, then you most likely don't have statewide rent control. However, we have seen them petition to add LLCs as being treated the same way corporations are, and it was shot down. Next year, they might try to change that again.
Just to let you know, some courts are including the LLCs in the definition of a corporation, which it really is under California law, but not all courts are doing it. So, you take your chances with an LLC and without the exemption notification sent out.
And if they change the law and you have an LLC, you're going to be then susceptible to it. So you may want to think about title and talk to your legal counsel and your tax person about how you should be holding title based on what they're doing. How long after the mayor declares the pandemic is over in RSA, LA RSO units do I have to wait to raise my rents? 1 year, 60 days? I believe the ordinance said 60 days.
I believe you're right.
Okay, so 60 days after the state of emergency is lifted in LA. Can I evict and have my daughter move in? She does not have a job and needs a place to stay. The tenants are 6 people. From what you said earlier, this would not be similar, I would think. LA County, multi-housing property, owner-occupied home with a triplex. Hey, did I train them right or what? They're telling you where, who, what? I did good. Dance around it, Fran.
Reading the current ordinance in LA County, the answer to that is yes, unless one of the other units is vacant and can be occupied by your daughter. Number 2, there will be relocation expenses that you would have to pay, and you would have to follow the rules under the LA County ordinance by applying for intent for owner move-in.
So you'd have to fill out the application with the city, pay the fund for the application, upload the relocation fees to escrow account.
Yes, if it's in the city of Los Angeles.
Okay,
If it's in an unincorporated area or the county of Los Angeles, then there are new forms available with the county to do exactly what you want to do with a notice of intent to move in and the requirements. The similarities between those and your daughter, you have to make sure that the current tenants are not elderly, disabled in any way. And then your daughter, if they're not, and your daughter is not, then you can go ahead and do that. If they are, and your daughter is not disabled, elderly, or the like, then you won't be able to do that.
so in other words, what he's saying is, if you're asking them to leave and they have a disability, your daughter better have a disability too. Okay, so they're like for like. Make sense? I hope that made sense. And if it doesn't, let us know. And then I see another question. Do you have any good news? I am not RSO. I hope I don't pay $15,900.
You won't.
And do we have any good news?
The only good news in all of this is we are training some of the judges to look beyond the financial declarations, self-certification, and asking them to allow us to cross-examine the tenants at their hearings, at their financial distress hearings. And what we're doing in our office is we are asking the tenant to bring their financial information to court for these hearings with either a subpoena or a request to produce. Some judges are allowing it. Some judges are saying they don't have to prove anything.
So we just need to know what we're up against based on what court we're going to be heard at.
That
correct?
is correct.
Okay, so big thing, you guys, before you file a case, talk to your legal counsel. Find out what goes on in that courtroom, okay? That's the most important. Now here we go. God love my people. You guys do great. City of Colton, County of San Bernardino, property owned by individual. CC 1946 was provided to the tenant. If a single family residence is sold with a Section 8 tenant occupying the unit, can the tenant be asked to move without paying relocation? Wait a minute. If it's County of San Bernardino, wouldn't that just be 1 month's relocation?
Except Section 8 may have their own limitations, which I don't see yet. I have not run up against that limitation. So to answer your question is If you sell it and you have it listed for sale under 1946, you can give a 60-day notice. Once escrow opens, you can give a 30-day notice. Within that notice, you should offer to pay 1 month's or waive 1 month's rent.
So you should, yes, to answer that question, yes. Because in my opinion, I think that you would be better off from an ethical standpoint if you offered that rent versus not offering it and then having your case get caught up too. Hold on. Why waive any rent? Just give the 90-day notice if the unit's sold.
You can do that. You can give 90-day notice and you don't have to do anything. But you have to notify your Section 8 caseworker that you're terminating Section 8 because you're selling the property.
There's that question answered. Good job. All right, does anybody else have anything for Joel? I was really excited to hear that we'll probably see something similar happening in San Diego just because they're so heavily populated and there's so much about tenant protections. And I'm sure we'll see it in other counties too, especially San Francisco, San Jose, places that are heavily populated come with heavy restrictions on landlords. One thing I did learn from this pandemic. We got more questions, Joel, bear with me. What if I try to evict? Can they bring up habitability? They put uninhabitability, but it's habitability.
The answer is yes. That is still an affirmative defense for non-payment of rent cases only.
Not for, I want my unit back?
Not for I want my unit back, not for breach of covenants, not for a nuisance other than LA County where you can't sue for nuisance right now. But yes, they can bring lack of habitability. And then you have to prepare your file. One, do a notice of intent to inspect, 24-hour notice of intent to inspect. Before you serve the notice, go in there, look at the property, determine what it looks like, who's doing what to it. Make sure you take pictures. If they don't allow you in, do it at least 2 times. And then lack of access, according to the state of California, denial of access, you can use that as a reason to evict.
Got that? Okay. Something else come through. Apply to.
Does which apply to Section 8? Are we talking about evict for and defense for habitability? Yes, there is a Section 8.
To waive rent.
Any defense can be used in an unlawful detainer case on Section 8 cases, but it's difficult in a Section 8 case to raise habitability because you have the annual inspections. And if your property passes the annual inspections, then there generally is not going to be a habitability claim. So make sure you go through your annual inspection and repair whatever's required to be repaired.
This one's for you because it starts with your name. Joel, is there still time to get your law degree? You're smart enough, or maybe run for LA mayor. That's my girl, Val.
Thank you.
Hey, he's my go-to, you guys. When you ask me a question, I go, huh? Hey, Joel, I got a question for you. And he'll sit down and talk to me and explain to me. And then I come back to you and put it in simple terms. Because sometimes, yes, he does use legal terms. And I go, huh? What did you say, Joel? He's the one that talked to me about a vexatious litigant that you guys all know about. How to go look that up on the court's website.
Right.
Make sure that you're not renting to a vexatious litigant. So thank you, Joel. You're my hero. He simplifies things because he'll say something to me and sometimes he'll use legal terms and I just do this at him. And he's like, oh, I get it. Okay, say it simple. Say it simple. I'm blonde.
Keep it simple and stupid.
Right? Because I'm stupid. So let's keep it simple.
No.
But yes, Joel is extremely educated as far as keeping up with the new laws, what they mean, what the restrictions are for landlords. That's part of his job duties here. Similar question, a house in Los Angeles County, Palmdale specifically, single family home. When can the owner ask to move in, given all the new extensions? And will we be able to evict for that?
You will be able to evict. You can do an owner move-in now. Depending upon the date it was purchased, who you're going to move in, whether you have a fixed term lease, not a fixed term lease, all of those issues have to be looked at, but you can do an owner move-in right now, applying to the county for the owner move-in with their application. Again, listed on the MLS. If you're not going to sell it and just move in, then advise the tenant, give them a 60-day warning notice that you want to move in. Send them a letter saying, hey, I want to move in. You're on a month-to-month lease. I don't want to go through the eviction process, so let's cooperate. Cash for keys is always a workable idea in that kind of situation, but limit your cash for keys to no more than 1 month's rent.
Unless you're desperate to get them out quickly.
Right. Correct.
Because sometimes money talks, folks. And like I've told you guys, there's really nowhere for them to go. So the reality is you're probably going to have to give them enough money to leave the state to get them out of your house.
That's
I'm just
probably-
saying, there's nowhere for them to go. So they're either going to have to move in with family or leave the state. And remember that if I had to go move in with family, you'd be paying me through the nose. I'm just saying. I'm kidding. I'm kidding. I love my family. All right, we got more questions. My tenant laughed at me when I offered 1 month's rent. Well, sometimes they'll
Yeah.
do that.
You're negotiating against.
Yeah, you
So-
know what you're up against
Yeah.
if they're laughing at you at 1
Yeah.
month's rent. And let's be honest, would you move right now for 1 month's mortgage payment? No, you wouldn't. So what's good for the goose is good for the gander. Please keep that in mind. He hasn't paid you rent in 2 years. Start the eviction.
Absolutely.
What city is it in? Let's start the eviction. Get it going. Huntington Park.
Non-payment of rent, you can do an eviction.
Yeah.
You can do an eviction right now on non-payment of rent. They then put the burden on them. Serve a 3-day notice to pay rent or quit with the notice from the state of California about rental assistance. Make sure you give all the disclosure notifications and start it and put the burden on them. Let them apply for a hearing.
He applied for rent relief, so you apply for rent relief, and if you get paid, hit the easy button. If you don't get paid, continue with the eviction. Basically, the way I see it right now, and Joel, correct me if I trust and believe that, is it's basically a race. Can I get them evicted through the court system before the government pays me? What's going to happen first?
But you have to apply, a landlord must apply for rental assistance to commence an eviction for non-payment of rent. For rents owed after October 1, 2021, you have to apply for rental assistance, get that application number, case number, send it to your tenant. They have 20 days in which to respond by using that case ID number and apply for rental assistance. If they don't, then the court will issue the summons and complaint, and you'll get a default judgment if they don't answer.
Okay, and then is it a 3-day notice on the 5th day? No. What does your rental contract say of when your rent is due? If the rent's due on the 1st, then it's delinquent on the 2nd, most likely, depending on if it fell on a holiday or a weekend. So if your rent's not due till the 20th, then you can't serve a 3-day until the 21st. Okay, so it has to do with what your rental contract says more than anything else.
And you count calendar days, not weekends
Correct.
or holidays.
Correct. Hold on. We recertified on October 20th and that's somebody else's question. I served on 10/21 a 3-day notice.
Fine,
Perfect.
fine.
Did you start the eviction yet? Because that's where your next step is. Can you serve a 3-day as of today? You do not need to wait till the 5th. Oh, you can serve a 3-day, depending on what the rental contract says. If it says the rent's due on the 5th, then you can't serve a 3-day to the 6th. Okay, it has to be past due before you serve the notice. It has to be delinquent before the notice is served. We have another question. I haven't, but I would be glad to start an eviction. Well, give a call to Fast Evictions. Joel would be more than happy to help you with your case. He's not going to answer your phone call when you call in though, so don't try that one. He's like, Patty, what are you doing to me? Don't make everybody call me today. But no, Fast Evictions would be more than happy to help assist you with the case. I don't know who your legal counsel is, and I'm not trying to shove Fast Evictions down your throat, but hey, I used them for 10 years before I ever went to work for them. That has to say something. Tony is my LARSO girl. If the property's in a trust, when can a widowed, elderly, disabled owner do an owner move-in? Owner wants, oh goodness. Owner wants to move into one of their multifamily units. It's located in the unincorporated area of LA County in East LA under RSO. Both tenants have been there over 8 years. They're in their 30s and they will claim they are disabled. What are current relocation fees to pay? This is a second attempt. We got caught with COVID in court in early 2020 and we dismissed our case without prejudice.
I don't know the total amount of the relocation that you would have to pay. I would have to look that up. But who's the trustee of the trust?
Her mom.
If the trustee of the trust is the elderly person,
Yes.
then the elderly person can do a notice of intent to move in and follow those procedures precisely.
It has to be done with like a game of chess, girl, with precision and accuracy, not a game of checkers.
So I would have to look up the relocation amounts. It may not even exceed, in LA County, East LA area, it probably will require $10,000 to $15,000 for relocation expenses, but I have to look that up.
I want to say if they say they're disabled, it's about 23 or
Yeah.
24,000,
Right.
but we're not quoting you an exact number, girl. Just think 25K, okay?
We would have to
Just
look that.
guess at 25K. I had started a case with Fast Eviction in April. Thank you for your business. We got rent relief on that at that time, so I stopped the case. Perfect. That's what you do. It's a race. If Housing is Key runs out of money, what can I do were affected by COVID and cannot pay their balance owed for January of this year rent and now February? This is in LARSO. We both applied with Housing is Key, but who knows at this point if they will pay. Their lease expires on March 31st of 2022.
All right, in a case like that, you may want to wait till the expiration of the lease and start on that basis. Expiration of lease cases are a little bit complicated right now, but they can move forward. One of the things you need to do is send a notice of non-renewal now that you're not going to renew the lease.
So they have
For
plenty
any
of, so
circumstances.
that they have plenty of time to prepare.
For
is
any
why he's suggesting
circumstances, then it expires on March
31st, whatever they
31st.
said.
As far as the non-payment of rent and Housing is Key, start your eviction. The 3-day notice, if the application has been pending for more than 20 days, get on the phone and talk to that caseworker if they'll answer the phone and find out what's holding up. If the tenant has not given the full information for Housing is Key, then that is an at-fault eviction, non-payment of rent.
Wait, hold on. That's an at-fault eviction. Keep going.
For non-payment of rent, and when they come into court and file their financial distress declaration or a forfeiture declaration, you have your paperwork that says you applied for rental assistance, they applied, it's still pending, but it's pending because the tenant has not completed their portion of their application. You will then prevail.
Most likely.
Yes. It depends on who the judge is now, because we have new judges in LA County doing evictions, and we're have to educate them more and more.
Yes. So to deal with the Trump, if you will, the big flush or the tidal wave of evictions that come into the court, did they appoint other judges to help overhear the evictions so that we could get them going through the system?
No,
They're just new judges.
they're just brand new judges who are coming on the evict in their rotation. They rotate. So we have new judges that are being appointed to handle the eviction cases. When those courtrooms are not available, they send you to regular civil courtrooms, sometimes even criminal courtrooms, where the judges know nothing about evictions. And your attorney and your witness have to be able to educate the judge on what's going on.
In other words, you're going to have to be able to quickly quote civil codes to the judge so that they can go back in their chambers and reference what the law is so that they can proceed with the case. No joke, okay? It's really happening. I think we have another question. Let me see what that is. If housing is key, oh, we got that. And that hers for the housing is key if they run out of money and they can't pay their balance
Yeah,
for
if they
January.
run out of
They're
money,
in LAR, so.
if they run out of money, then there's no money to pay for rental assistance.
Housing is key is just processing early December applicants, to my knowledge. Many of my applications are still pending from December 6th. When I call, they say the case is under review, no new news. They're overstaffed and underpaid just like the rest of the nation. I mean, they're trying.
Well, you can still start your eviction based on the pending application if it's pending more than 20 days.
And she's in Kern County.
Okay, you can do that.
Yeah.
In Kern County, as long as the information on the plaintiff's mandatory cover sheet and supplemental allegations, which the landlord will sign, marks the right box that the application has been pending more than 20 days. Then it's a question of proof of why it's pending. And if it's simply going to be, it's pending because housing is key has not gotten to it, then the court will most likely continue it for a period of time until they do get to it.
Did that help you? I know what she's wondering. Do I start eviction or do I wait for the money? Do I do eviction or do I wait for the money?
I would start the eviction. I mean, it's money out of your pocket either way.
And in the meantime, if they run out of money, at least your eviction's in order.
And you're in the queue.
Right. At least, yeah, you're doing something, whether it's the right thing or the wrong thing, at least you're being proactive. Right?
Right.
At least you're doing something. I also saw that Housing is Key is offering mortgage relief for landlords. That's something new that popped up on their site, but I'm sure as soon as they run out of money, it's gone anyway. But if that's something you need, Housing is Key is a place where you can apply for mortgage relief. I'm just adding my 2 cents. I just
Good.
saw that when
Okay.
I scrolled through there the other day.
Good.
Anything else that you want to tell them? I have LA County in here mostly, Kern County, San Bernardino County. I'm just looking at my list of people. Who's in here.
Landlords and property managers have to be proactive with their tenants. You need to establish a rapport with these tenants that basically tell them you're in control of the rental property. They have to obey the rules and regulations. Don't be
Submissive.
a nice person and say, oh, we understand what's happening. We'll let certain things go. When you let certain things go, that's a waiver of a legal right. So if you let certain things go, they can bring that up as a defense.
Let me give you an example of what he's talking about. Let's say your tenant pays the rent. Your rent's due on the 1st, and every because of that. and you've had enough. So on the 2nd of the following month, you want to serve a 3-day notice and pursue an eviction. You may have wavered when your rent is due by accepting it late for so many months in a row. Make sense?
One thing you can do to avoid that is even if they pay late every time, with your receipt or any information you send them upon acceptance of the rent, saying this is not a waiver of my right to demand rent paid on a certain date. Check your lease also, because most leases have an anti-waiver clause, but that can be waived. Anti-waiver doesn't mean it can't be waived. So look at that and be vigilant in informing your tenant that you're not waiving anything.
And then let me see, we had something else come through. Oh, it's a long one. It's Tony. She's my LARSO girl. In the unincorporated area of in East LA under RSO, I have a separate parking agreement, distinct and separate from the rental agreement. Can I give a notice to terminate the parking agreement to the remaining 2 tenants out of the 7 without it being considered retaliation or whatever they can think of? Property does not have garage or carports.
If BOSTA or Eviction Defense Network get that case, they're going to argue an illegal reduction in services. There is no reason why you can't terminate that agreement except for that defense. As long as it's not part of the rental agreement, but you have a separate agreement where they're paying for that parking space, you can.
Especially if it's a license to park and not an agreement to park.
So there is, you are on the edge of the law, but there's no reason why you can't do that.
You're kind of in the gray area, girl, but it might work. Joel's like, yes. He knows, folks. Okay. They do not pay for anything.
Okay, then terminate it. Then it's not a reduction in services.
If they're not paying you, you're not providing a service.
Right,
Just saying.
that would be the argument.
All right, I don't want to keep Joel any longer because he has a busy day and I have to buy him lunch for helping us today. He's great, you guys. Anytime that I can have him come back, I will have him come back for our Wednesdays. Does anybody have anything else for him before I turn him loose and let him go? Yep, here it comes. Oh, it's Patty. Wait a minute. I'm not clear on LARSO and COVID rules. What can I do if the tenant stops paying rent?
LARSO is a at-fault just cause eviction for non-payment of rent, even given the extension of the pandemic. You just have to follow the rules. You have to serve the proper notices. You have to serve the notice from the state of California about rental assistance. Make sure all the proper current COVID notices are out there. Start your eviction after the 3-day notice to pay rent is expired. Make them come into court and show their financial distress.
And I'm going to say what I've always been saying, you guys buckle up. We are waiting for the economy to crash, for the real estate market to crash. We've been waiting for it for some time. I don't know what's going to trigger it, but at some point it is going to go the opposite direction that it is currently going. So we may have to adjust our tenants' rents accordingly just to keep them in the property so that we aren't dealing with a bunch of vacants. Just saying.
Good advice.
It's not advice, it's an opinion,
Okay.
but I foresee that we can't keep going the way we're going. You guys, the bubble is going to pop at some point. And when that happens, most likely we'll be trying to keep the tenants in there paying rent at a lower amount rather than flipping vacant units. Flipping vacants is very costly. Please keep that in mind. Don't just think you're gonna go put paint and carpet. Sometimes you got to do a whole lot more than that. So keep that in mind. Sometimes it's like a nasty divorce. It might be cheaper to keep her. And yes, that's how I talk to them. They giggle with me. They like it.
Or cheaper to keep him.
Yeah, it's cheaper to keep them, cheaper to keep her. I mean, sometimes I've been through this before. I know how it goes. And when the economy goes down, I had rents that were $1,500 a month in Victorville, and they went down to $895 in a matter of 4 months. $895 in 4 months. So you gotta hustle to keep them, lock them into that new contract. But the reality is, it's cheaper to keep them. You may have to lower that rent and adjust their contract to keep them there. And I saw one more thing come through, Joel. I just want to make sure it's something I can answer. I want to keep my unit vacant. It's not worth the trouble. Can they bust us for having vacant units in some cities?
No.
Never, ever, not so ever. So
No. That would clearly, and I think most of the rules are unconstitutional, but that would clearly violate a landlord's right to do what they want with their property.
yeah, I mean, it's all a bunch of bureaucracy and bullshit
Yep.
anyway. I mean, let's be honest.
I agree.
But for those of us that are in the devil's cauldron, being the county of Los Angeles or the county of San Diego, we may want to consider selling now while the market's high. And I will not represent you, so do not think that I'm telling you the sky's falling. I don't do sales transactions, but I am a broker. We may want to sell and relocate our funds to counties that don't have so many restrictions. Just saying, something to think about. And you've heard it your whole life. Buy low, sell high. So now it's high, it's time to sell. Yes, and Val says time to sell. Yes.
Thank you, everybody.
All right, bye, Joel. Thank you. Thank you. Does anybody else have anything for me? And thank you again, Joel, for joining us.
You're welcome.
No problem. Anybody have anything for me? We got him for 52 minutes, you guys. That was awesome. Yes, great meeting. And this will be up for replay. So if you guys need to reference it at a later date, not a problem. And I'm going to have him back to help us navigate through this storm, if you will, as we need to. But with that new moratorium being extended and the new dates that were put into place, I just wanted to make sure that I had good, solid answers for you guys. So hence why I did that. Remember, I told you I had a surprise. Buy him a big lunch. You got it. Yes, I am sitting in the office of Fast Evict. I'm here. So if you guys need to do an eviction, feel free to call Fast Evictions. We would be more than happy to help assist you. Let me see. I try to give so much info. You know me, Stacy and Colleen. Come on. I try. And Joel's extremely thorough, and he does tend to speak in terms that we all understand rather than the attorney who sometimes talks up here. Oh, thank you guys. Thank you guys for being members of Widget's Way and supporting me and being a group that we can all utilize together and bounce ideas and suggestions off of. It's one of the things that I appreciate the most about this industry is the fact that I have all of you. We're a team. And thank you guys for submitting your questions with if you're affected by RSO, if it's a single family residence, if you're subject to statewide rent control, because he laughed when he saw that come through. And I'm like, I've trained them well. They know what we need to answer their question. I can't thank you enough for that. It really does help us get through the questions a lot faster. And even when you call your legal counsel, start the question the same way. Give them the facts they really need to know right out of the gate, because it helps them give you a more definite answer. All right, you guys, I'm going to go buy Joel lunch. I'm going to buy him a good lunch, just like you said. He's really good. He's very thorough what he does. He prepares a lot of the legal documents for trial. So he does a lot of stuff with briefs and things of that nature. So he knows what's going on in the courtroom because he's dealing with a court jury trial debacle kind of stuff. So he's aware of the outcomes, how long it takes, all that kind of good stuff. If nobody else has anything, goodbye and thank you. I will be back next Wednesday. If you guys need anything, you know how to hunt me down. There is no case law yet, still to this day. Remember I told you it would be a nightmare? We still don't have case law. Can you imagine if you were that owner that's going through a case that's going to be case law that's been happening since March of 2020 with no income. My God, I can't. It just makes my skin. I can't imagine. I can't imagine the agony, the stress. But there is no case law yet. No case law regarding COVID or pandemic or any of this. None. And you heard Joel, and I think it too. I think we're going to see some more tenant protections coming out of San Diego because they are heavily populated. It happens in heavily populated areas. I'll get that word out. Can an owner sue for emotional distress in that situation? In what situation? And no, we as owners can't sue for emotional distress. Come on. Nice though, wouldn't it? Wouldn't it be nice? It's just, it sucks. I mean, I can't imagine. How much are your legal expenses over 2.5 years? Right? Right? With no income the whole time and no results. It sucks. 2 years with no rent. Yeah, I know. I agree, but the answer is no. The owner is going to be able to sue for emotional distress. Remember, the courts see landlords as having deep pockets. They think we're all bazillionaires and can afford everything. The reality is we invested in real estate hoping that it would pay off for us, and look at us now. Right? All right, you guys have a great week. Thank you again. And if you need me, hunt me down. You know how to find me. Bye, guys.